Hi everyone, this is a talk on human rights and the response to COVID-19 in Cyprus. The talk will be divided into three parts. The first part will describe the measures that have been adopted in Cyprus in order to respond to COVID-19. The second part will identify the human rights that are potentially affected by this situation, whether they are restricted by the measures or whether they're in fact violated, is something that we will briefly look at. And the third part will examine whether Cyprus should derogate from its human rights obligations or whether it should continue with a situation of business as usual, if you want. Okay, so starting with the first part, the measures that have been adopted to Cyprus in order to respond to COVID. So Cyprus to date, so on the 21st of April when this is recorded, has had close to 800 positive cases of COVID and close to 20 deaths related to COVID. From very early on, from the beginning of March, it has adopted a rather strict lockdown policy, which is similar to other European states. So, to explain what this means, it has closed all schools from kindergartens up to universities. All universities and some schools are offering remote teaching and others are not offering anything. It has asked everyone who can work from home to do so. And it has closed certain establishments totally. So malls are closed, restaurants are closed, shops that are not selling, necessary products like supermarkets or pharmacies are closed, and religious institutions remain closed. And people are asked to stay at home. Okay, so the way that lockdown works is people are allowed to leave their house once a day. And in order to leave their house, they have to send a text message to a government number explaining why they're leaving the house. So there are there's a specific list of things that you are allowed to do when you leave your house. That is visit the pharmacy, visit the supermarket, visit the bank when e-banking is not possible, necessary visits to state institutions, moving in order to help people that cannot themselves move. For example, if you have an elderly parent and they have to be taken care of, you can do that once a day. Physical exercise within the area in which you live. It should be noted that if you do any of the above, so if you go to the supermarket or if you go to your mother or father who cannot move themselves, you're not allowed to take your morning exercise on the day or your daily exercise on that day because you have used up your once out of the house ticket. Attending a ceremony, for example, a funeral or a wedding, in case that is not cancelled, but that has a cap of no more than 10 people. And if you have any other specific reason, for example, you have to go to work because, I don't know, you work in a supermarket or you work at a pharmacy, you have to disclose that reason. So you're not allowed to go out. Police presence is clear. Okay, you see policemen around the streets. So people who do go to work every day are stopped every day by the police, and they have to explain where they're going. The last measure that had been adopted by the government, it has now been abandoned, was that students who were abroad at the time that the measures started were prevented from returning back to Cyprus. They were not allowed to return back unless they had a certificate indicating that they were COVID-free, which in many countries you cannot get that certificate. So in reality, that meant that they were denied access to the country. That policy has now been abandoned, and the repatriation of students has started, and it is expected to be completed by June 2020. So this is the situation in Cyprus. As I said, it's not atypical. There are other countries in Europe that have adopted similar measures. So the question that arises is, are these measures compatible with human rights? What's the situation there? Well, the first human right that comes to mind when you think of a lockdown is Article 5 of the European Convention on Human Rights. I will be referring to the ECHR throughout, but these could apply to any other human rights instrument. So equivalent protections exist in the ICCPR, the International Covenant on Civil and Political Rights, or in the American Convention on Human Rights, or in the African Charter of Human and People's Rights. So Article 1 of the ECHR protects the right to liberty and security, which primarily relates to situations that have to do with deprivation of liberty. So if your liberty has been deprived, Article 5 is engaged, and unless there is a good reason from the government why it is depriving your liberty, then that results in a human rights violation. Now, the most suitable reason that the government could use in this case is found in Article 5, paragraph 1, subparagraph E, which relates to the lawful detention of persons for the prevention of the spreading of infectious diseases. The problem there, however, is that there hasn't been a case so far where a government was able to use this exception in order to interfere with the liberty, in order to deprive the liberty of healthy people, okay? Because we are all in our houses, but we're not all sick, yes? There is a potential here that we could be sick and we don't know it, or there is a possibility that if we go out, we could get sick and make other people sick. But the vast majority of the people who are the subjects of the lockdown are very much healthy. So that creates a very difficult situation for the court if such a case was to go to the court, because the court will essentially be asked to answer the question, can you lock up, can you deprive someone of their liberty if they as a person do not possess a characteristic that makes them dangerous? Okay, so if you think about the other exceptions of Article 5, it's when someone has committed a crime and they have received a fair trial and they are therefore imprisoned. Or it is when someone, the classic example of this infectious diseases exception is when someone has an infectious disease, there is proof that he has an infectious disease, and therefore he is locked up until the situation is resolved. This is dissimilar to what we have in Cyprus and elsewhere at the moment. I'm not saying that it is definitely a human rights violation, but I am saying that it is a novel situation that the court will be forced to look at. And I think the solution to this conundrum of the court, how do I balance the very obvious need to keep people at home in order to flatten the curve and human rights protections, I think the answer to that lies with derogations, which is what we will look at later. So the second right that is potentially infringed here is the right that protects freedom of movement. Now, that is protected under Article 2 of Protocol number 4 of the European Convention on Human Rights. And the difference between freedom of movement and the right to liberty and security is simply one of degree. So if you were to put this on a graph, Article 2 of Protocol 4 relates to restriction of liberty, and Article 5 relates to the deprivation of liberty. And it is simply the case that the deprivation of liberty results in more serious limitations to one's liberty than the restriction of liberty. So even if Article 5 is not engaged, in other words, even if someone was to successfully argue that there is no deprivation of liberty here because people are allowed to leave their houses once a day, there is very clearly a restriction of liberty. That is undisputed. That is not to say that there is necessarily a violation of the right. It could be that there are very good reasons, and I think there are very good reasons why that right is restricted, but it is for the government to prove that it is in fact necessary to keep people locked up for such long periods of time. The other thing I should note about this article is that, as I said, the freedom of movement is a right protected under Article 2 of Protocol number 4. But even though Cyprus has ratified Protocol number 4 and therefore is bound by its provisions, not every European state has. So Protocol number 4 has not been ratified by Greece, has not been ratified by Switzerland, by Turkey, and importantly, considering what is happening in the UK at the moment, it has not been ratified by the United Kingdom either. So that is the second potential violation that exists here, or restriction of human rights. And then we go to an array of rights that are engaged. Let's start with Article 11, freedom of association. The idea of the lockdown is that you do not associate, you do not meet with people who are not residing in your household already. Or if you meet with them, you do so because it is absolutely necessary. It is because you work with them and you cannot work from home. It is because you accidentally run into them at the pharmacy or at the supermarket, or it is because you absolutely have to go see them because they are your parents who cannot move, for example. That is a restriction on freedom of association, which is protected under Article 11 of the ECHR. The other situation in which this arises is, of course, touch wood, when there is a funeral happening, there is a cap on the number of people who are allowed to attend. So you wouldn't be able to have a funeral of more than 10 people, which in Cyprus, in most families, that would not even cover grandchildren, or at least it wouldn't cover all grandchildren, because many families have more than 10 children and grandchildren put together. Article 12, freedom of expression, is another right that is affected. You are not allowed to meet with people in order to express yourself. You're not allowed to share your opinion face to face. Of course, you are freedom to share your opinions and express yourselves online. That has not been affected in any way. Article 8, the right to private life. Now, that is engaged for a number of reasons. First of all, because the very fact that the government stops you from doing things that you would have done in your private life beforehand, like visit a family member who is not living in your household and does not fall in the exception of someone who cannot move themselves, or simply go out and meet someone. All of these fall within the right to private life. An even more fundamental restriction of the right to private life, however, has to do with the fact that in order to go out, you need to notify the government and you need to explain yourself to the government. Essentially, you need to get permission, because if, for example, it's the second time that you're sending a message that day, you will get a reply from the government saying that you're not allowed to go out, which is definitely a restriction of your private life. under no other circumstances would you be forced to explain to the government that I'm going to this pharmacy today, or that I'm going to my parents today, or that I'm going to a funeral today. And that, of course, raises questions as to how that information is stored by the government, for how long, who has access to it, and how your personal data is protected, because there are three things that you are expected to send in the same text to the government in order to get permission: your ID number, your postcode, and where you're going. Now, if you put those three together, someone can have a very accurate picture of what it is you do when you go out on a daily basis. I mean, this has been going on for a month and a half now. Again, that is not to say that the right to private life is violated. It could be that there are very good reasons for this restriction, in which case the proportionality test would simply conclude that there is a restriction of the right to private life, but the restriction is a legitimate one, it's a necessary one, it's a proportionate one, it's in the interest of the democratic society, and therefore it's not a violation of Article 8. In the contrary scenario, that would be a violation of Article 8. For example, if it was concluded that there is a restriction that is not necessary. There are three more rights that I would like to focus on. The first is Article 9 of the European Convention on Human Rights, freedom of religion. People are not allowed to go to church. For many people, this was a major interference with their right to practice their religion, especially because the limitations also spanned through Easter. Okay, so this was a time when people in Cyprus do go to church. Many of them go every day to church during the Holy Week, and they were not allowed to do that this time. Again, the proportionality test, in the same way that is applied in Article 8, the proportionality test would be applied for Article 9 as well. The one before last article that I would like to focus on is Article 2 of Protocol number 1, which protects the right to education, and that relates to the fact that the schools are currently closed. It's the 21st of April today, and it's not clear when schools will reopen, whether schools will reopen before summer recess begins. It's not clear how the material that has not been covered will be covered and when. It's not clear how students will be assessed to go to the next year, or whether they will go to the next year. And it's not clear what's happening with those who are graduating from secondary education this year and are waiting for their end of year marks in order to decide what university they're going to, or if they're going to university. So all of this is a question mark, which will need to be addressed sooner rather than later, and the answers to that will determine whether there is a potential violation of the right to education. The last right that I want to briefly mention is Article 2 of the European Convention, which protects the right to life. Now, traditionally, Article 2 had a negative obligation attached to it, that is, do not kill. Over the years, and in particular after Osman and the United Kingdom, the European Court has read positive obligations into Article 2. So Osman and the United Kingdom has made it clear that the state has a positive obligation to take preventative operational measures in order to protect life. That applies in the case of the pandemic, because even though the pandemic is a natural disaster, and even though most natural disasters are totally surprising and unexpected, and therefore the state would not be asked to take operational measures and prepare for something that is unexpected. The states in this case had advanced notice that COVID-19 was coming. They knew since, at the very least, January 2020. So they had a couple of months at least to prepare in order to make sure that either no lives are lost or as few lives as possible are lost. So there are three possible categories of people that Article 2, the positive obligations of Article 2 could apply. The first is the general population. Is there a positive obligation to protect the general population at large? The answer is yes, there is clearly a general obligation to protect everyone, but whether there is a violation of that right, I doubt it. Why? Because you would need to prove that there is a causal connection between the state's failure to act and the death of a particular individual, which I think is rather difficult to prove. By the way, this discussion does not relate only to Cyprus, or even does not relate primarily to Cyprus, because Cyprus has done a pretty good job at keeping deaths down. We have more beds than what we have currently needed so far. The state has taken steps to make sure that we have a sufficient number of ventilators. There is a plan in place and it seems to be working. So this is all a theoretical discussion, luckily, thankfully, for Cyprus. Unfortunately, that's not the case in other European states or the US, one could argue. So even though I do not think that there is a violation of Article 2 in relation to the general population, there are two more categories of people that merit some discussion here. The first are the vulnerable, for example, the elderly. In particular, in cases where there is a refusal to admit someone to hospital, or, for example, in the case of the UK, even to test them. So what happens if you have an elderly person who shows signs of COVID and the state refuses to test, so we don't even know whether it's COVID, or the state refuses after testing to admit that person to hospital, and subsequently the person dies. There is a related case law from the ECHR on this. I think the most relevant case is Ashiye, Cenk, and Turkey, where the court found a violation of Article 2 when a newborn baby was denied admission to a neonatal intensive care unit. In that particular case, there were insufficient incubators because the state had not taken sufficient care to ensure the smooth organization and efficient running of public hospitals, which is potentially ringing bells. For example, in relation to the UK, the state has arguably not taken every step it could as soon as it was informed about the pandemic in order to make sure that it was well prepared. My personal assessment is that this does not apply to Cyprus. I think the Cypriot authorities were well prepared in this regard. So if the state refuses to test, and the reason it refuses to test is because its healthcare system is overwhelmed. And the reason its healthcare system is overwhelmed is because it did not take the necessary measures to ensure that it was not overwhelmed after it had advance notice that COVID was coming and it's bad. Then there could be a potential violation of Article 2. The last category of people that I want to discuss are frontline workers, such as medical staff, or people who work in pharmacies, or even people who work in supermarkets. And in particular, the debate that has been going on in many countries, luckily, again, not Cyprus, that has to do with the unavailability of personal protective equipment. So what happens if someone who has been a frontline worker, a doctor, a nurse, who has been forced to work during this situation, but they have been forced to work without the necessary protective equipment that would stop them from getting infected. The person catches the disease, and as a result of the disease, they die. Is the state responsible for a violation of Article 2? The most relevant case that I could come up with was Lopez de Sousa Fernandez against Portugal, in which the court said that in cases of negligence, the state only has an obligation to establish a regulatory framework for professional standards. In other words, the state usually, in the vast majority of cases, does not have that is not liable for an Article 2 violation simply because it was negligent. However, there is a positive obligation to protect life if the state has knowingly put in charge, if the state has knowingly put in danger the life by denial of access to a life-saving treatment. And this is due to systematic and structurally dysfunctional hospital services. So, to rephrase that slightly, if the state is refusing treatment or equipment that could be life-saving, and this is because the service, the hospital service, is structurally dysfunctional, and that is preventable, then there could be a violation of Article 2, which is what is arguably happening in some European states. Okay, so that concludes the list of human rights violations or human rights restrictions that that states have to think about. The last thing that I want to discuss is it a good idea to derogate? Okay, so let me say a few words about derogation in general before I move on to the question of whether states should derogate in relation to COVID-19. Derogation is basically a right that states have in order to reduce the level of human rights protection that they make available to their citizens or to humans in their territory in time of war or other emergency threatening the life of the nation. Okay, so the state can derogate when there is such an emergency situation, but only to the extent strictly required by the exigencies of the situation. Okay, so basically what that means in practice is that the state sends a letter to the European Court of Human Rights. It says there is an emergency in my territory. In order to respond to the emergency, I have to derogate from my human rights obligations for a limited period of time. And that's the end of the process. There are some rights that are non-derogable. In other words, the state is not allowed to restrict or interfere with those rights, even in times of emergency. For example, Article 2, the right to life, which we have discussed already. Article 3, freedom from torture, which we haven't discussed, but could potentially kick in, depending on the situation that someone finds themselves in. And Article 4, freedom from slavery. The other rights that we have discussed are in principle derogable, which is what makes this debate topical at the moment. The European Convention on Human Rights is not the only human rights instrument that allows derogations. As I mentioned, it allows them under Article 15. Article 4 of the International Covenant on Civil and Political Rights allows derogations, and Article 27 of the American Charter of the American Convention on Human Rights also allows derogations. At the moment, the following states have derogated from the ECHR: Albania, Armenia, Estonia, Georgia, Latvia, Moldova, North Macedonia, and Romania. Okay, and from the American Convention, the following states have derogated: Argentina, Bolivia, Chile, Colombia, Ecuador, El Salvador, Guatemala, Honduras, Panama, and Peru. We are in an unprecedented situation where about 20 states have derogated, which means that 1 in 10 states in the world, for the first time ever, as far as I know, has derogated from their human rights obligations. I should note that derogation is generally unavailable in treaties that have to do with economic, social, and cultural rights. The one exception to that is the European Social Charter, which does allow derogations. And I should also note that the fact that there is an emergency doesn't always mean that there is a reduction in the level of human rights protection. For example, there are some human rights treaties, such as the Convention on the Rights of Persons with Disabilities, which require a heightened protection of human rights during times of crisis. The relevant article, for those who want to look that up, is Article 11. Just a side note, because I have mentioned European social and cultural rights, there are clearly implications to socioeconomic rights because of COVID. People are losing their jobs, they're getting fired, they're losing their homes, they're getting evicted. That will result in food shortages. For some, these are clearly situations that result in infringements of socioeconomic rights, but I'm not discussing them in this particular talk. So, having given a brief outline of derogations, the question arises, should states derogate in this situation? Well, there is a debate between those who say that states should not derogate and they should continue with business as usual. And the reason for that is pretty convincing. It has to do with the fact that emergency measures have a tendency of outliving emergencies. So if states derogate, they are giving themselves the power to adopt even more restrictive laws, and those more restrictive laws are likely to stay in the law books even after the emergency is over. The other side of the argument, which I personally agree with, and that has been compellingly made by Alan Green, is that Article 15 is there for a reason. Okay, those who argue that states should not derogate support the position that it's not necessary to derogate because the court will simply encapsulate the considerations that are relevant to COVID-19 into the proportionality test. In other words, when the court is asked, is there a violation of Article 5? Is there a violation of the right to liberty and security of the person? It will probably conclude that there wasn't a violation because it was necessary to restrict the right to liberty in order to protect the nation from the spreading of an infectious disease. However, as I explained before, this would be the first situation, if the court concludes that, it will be the first situation in the court basically justifies the limitation of the right to liberty on grounds of the prevention of an infectious disease for people who are healthy. That does not set a very promising precedent. It is something that as a human rights lawyer, I would be incredibly uncomfortable with. And the way to address that is to say, yes, had there not been a derogation here, the lockdown measures would result in a violation of Article 5. However, bearing in mind that this is a pandemic and a lockdown is indeed necessary, because of the derogation, because the states informed us in advance that it was necessary to restrict the right to liberty, the right has not been violated. That's it in terms of a very general overview of the implications of COVID-19 on human rights. My personal advice to the Cypriot government, for however much it's worth, is to derogate. If there is an emergency threatening the life of the nation, it is this one. I think they should have derogated already. Other than that, I think they're doing a pretty good job. Thank you very much for listening.